the legislature saw a need for the statute because of a well-documented history of problems with injunctions in cases arising out of labor disputes.
Doesn't the statute favor certain speech over others?
Justice Liu, it does not. It's not a statute that is about speech. It doesn't regulate speech on its face.
Does it make a difference that it affects speech?
Well, it doesn't, Madam Chief Justice. And this is the heart of what Ralphs has been seeking to argue. According to Ralphs, any statute, even a content-neutral procedural statute like 1138.1, that in some subcategory of cases may have an effect on speech, and here an effect on Ralph's ability to restrict speech, any such statute, according to Ralph's, violates First Amendment content discrimination principles. That is a quite radical theory. And as we've pointed out, accepting that theory would not only mean that the federal Norris LaGuardia Act is unconstitutional, its language matches identically that in Labor Code 1138.1, but a host of other purely procedural statutes would also be challengeable under strict scrutiny standards.
Well, let's just focus on 1138.1 for a second. This is a statute that pertains to labor disputes, right?
It applies to any case that involves or grows out of a labor dispute, correct.
Okay, so that already itself is a content-based distinction, is it not?
Well, it's not a content-based distinction regarding speech. It's a content-based distinction regarding categories of cases. And as we've noted, under the federal Norris LaGuardia Act and under 1138.1 as well, there are a host of cases that could be implicated in the statute, in which the statute would apply, that have nothing to do with expression. Ralph's, the state is not, the government is not restricting speech here. The government, in enacting...
It's not restricting speech, but I take it your opponent's argument is that it's favoring certain kinds of speech.
Well,
right?
and
I understand there's a difference here. There's no speech being stamped out. But on the other hand, you know, the force of your opponent's argument is that government is picking and choosing among speech that it likes and doesn't like, or speech that it wants to protect and speech that it doesn't want to protect. And it's doing so on the basis of its content.
Well, I would agree that in the case of the Moscone Act, the legislature has said that this form of speech is important and that protecting is important. The problem with the First Amendment theory that Ralphs has raised is that that does not mean that it's content discriminatory. There is no abridgment of speech in either statute. And so, as to your comment, the part that we do not agree with is that the state government in either statute, but particularly with 1138.1, has said, we disagree with all other forms of speech. If Ralphs were correct that this constituted an abridgment of speech, well then what do we do with other statutes that do exactly the same thing as the Moscone Act, the National Labor Relations Act? That act gives employees an affirmative right to be on their employer's property to speak about unionization, but not to speak about religion, politics. According to Ralphs, that is an abridgment of every other form of speech that is not encompassed by that statute.
It's your position then that any picketer could come onto the private property of the store and picket against any business activity of that store, whether it's labor, whether it's the produce that's being produced, whether it's no matter what it might be. Is that right?
Yes, Your Honor.
So you're not limiting this to the subject of labor negotiations as such. It's a lot broader than that, in your view.
That's correct, Your Honor. The Moscone Act incorporates the existing right for speech related to a labor dispute, but that is a broader constitutional right that has been recognized in In re Lane and Schwartz-Torrance and ratified by this court.
Is it fair to say that your interpretation of 1138.1 really hinges on how we view it? Whether we view 1138.1 as a restriction on speech in violation of the First Amendment, or if we review it instead not as a restriction on speech, but more to the point of a restriction on court's jurisdiction during a labor dispute. And if we view 1138.1 as the latter, then you're saying there are no First Amendment implications from 1138.1.
The latter interpretation is certainly correct. That's exactly what this statute does. That's exactly what the Federal Norris-LaGuardia Act does. There are certainly no content discrimination implications. This is a distinction not between categories of speech, between categories of cases. And so even within a case that's governed by 1138.1, it doesn't matter what the expression is. It doesn't matter what the content of that expression is. If it arises out of a labor dispute, then that provision applies to any injunction that might be raised in that case.
You're making that argument about 1138.1, but not about the Moscone Act.
The Moscone Act is a different act. It has procedural aspects, but it also has a substantive aspect. And so the statutes are different. Moscone is constitutional, though, for many of the same reasons as 1138.1 is. It doesn't abridge anyone's speech. The abridgment that is being sought here is being done by a private party, not the state. There's no state action.
The state action, though, is the favoritism.
Well, again, there isn't a favoritism that's involved here. There is a protection.
Sure there is. I mean, if you want to go onto the sidewalk in front of Ralph's to protest, animal fur, you're not going to get very far because you can get an injunction against that.
Well, not under the Moscone Act.
Not on the Moscone Act, but assuming this is not a public forum. I mean, that's all with that assumption in the background. But in other words, but clearly it's content-based because it's about labor.
Justice Liu, to be clear, are you speaking about 1138.1?
Moscone Act, the Moscone Act.
The Moscone Act, we don't believe that it can be seen as favoritism any more than the National Labor Relations Act would be unconstitutional.
In terms of the Moscone Act, it tells courts hands off on injunctions involving labor, speech, expressive activities. When you tell the courts that it's hands off on their ability to issue an injunction, why isn't it exactly what Justice Liu has described it as?
Your Honor, favoritism, even if that were how it were fairly characterized, would not create a First Amendment abridgment for the reasons that we've said. There's no state action in the abridgment. Many statutes, like the National Labor Relations Act, confer a similar right and abrogate the common law on a partial basis. Supreme Court doctrines, for example, the extension of the New York Times v. Sullivan actual malice standard to cases arising out of a labor dispute, which the Supreme Court held in Lynn versus Plant Guards. That's indistinguishable. It abrogates a common law right for some, but not all. That fact, the fact of protecting a certain sort of speech in a certain sort of situation, and not, as Ralph's would have it, having a universal protection, does not create content discrimination.
The statute does contemplate a balancing of interests, does it not?
To be
in
clear,
paragraph 3?
Are you speaking about 1138.1?
Yes, sir.
It does, yes.
And so I guess my question is, if the public courtyard is 30 yards or 50 yards away, a little bit bigger than the width of this room, I imagine, wouldn't it be legitimate to balance the interests of both parties to say you can't picket right in front of the door, but there is clearly a public forum immediately adjacent to the entity with which you have a dispute, and you're more than entitled to engage in your free speech activity there?
Your Honor, I think that would be a question for the reasonableness of the time, place, and manner restrictions that were adopted. And that, in terms of 1138.1, would go to, has there been an unlawful act here?